You're listening to 105.9 The Region, and welcome back to On the Market, York Region's exclusive radio real estate show. I'm station manager Tina Cortez, and my co-host is Asif Khan with RE/MAX Prime Properties.
Thank you, Tina. Joining us next is our resident expert in the real estate law field, Ricky Rathor from Rathor Baig Law, and Ricky's also the principal at RE/MAX Empire. Ricky, welcome back.
Thanks, guys, for having me again.
Ricky, we were talking about tenants offline, and, tenants are great. They help pay down your mortgage, but sometimes things can get a little tricky.
That's right. And ultimately, Asif, what I like to tell clients is that your Residential Tenancies Act, first off, is very different from the Commercial Tenancies Act, is the Bible when it comes to all things dealing with the residences that are tenanted. And so it's a very particular piece of legislation, which is enforced by tribunal members that are very specific. And so if you don't adhere to the requirements of the Act, you end up just going in circles. And more often than not, it's people who try to save a little bit of money attempting to deal with the Act on their own when it comes to serving notices and all the other stuff that end up losing in the long run.
And let's talk about serving notices, because we had a lady call us that wanted, she said, hey, we're getting engaged over the holidays. We have this property. We've just got a tenant, but we want to sell it. And if they haven't given proper notices to the tenant and they've just started this lease, that's going to be an issue.
Absolutely. So there's a couple of things, Asif and Tina. First and foremost, what I want the listeners to appreciate is that you've got to treat your business in real estate like a business and not a hobby, right? And more often than not, that means spending and allocating the resources required to hire a paralegal who goes to the tribunal on a day-to-day basis and fights these sorts of cases and files the notices. As a lawyer myself, I don't even bother going into that situation, and I hire paralegals on behalf of the company to go and enforce these notices and file everything that's required, because they know the nuances, they understand it. So first thing is that you've got to make sure that you've got the right people that are equipped and have the knowledge required. Now, going to the question, so in a scenario where a client will call me and they'll say, Ricky, I want to list my property. So going back to the scenario, we've got a couple here that's getting engaged. They want to sell their property. They call the real estate salesperson, probably someone from your office, Asif, and they'll say that, Asif, come and list this property, right? And so the first question I get as a lawyer is, what notice do we give this current tenant so that we can stage the property and have them removed so that we can start the showing? And the reality is there's no such notice for such a thing. You cannot give a tenant a notice unless and until you have sold the property firm. And it's very specific legislation.
So suppose we get to that closing or the sold firm date, and we say, hey, tenant, we've sold this property and it's going to be closing in 60 days or 90 days. Take us through that process. What happens then? What type of notice has to be served? Because I'm sure there's our listeners out there are thinking, hey, I have a property and I have it tenanted. What if I need to sell off my assets at sometime during the year before that tenancy ends? What are the forms? How do you give notice? And what could or could not happen?
Okay, so let's walk through a scenario. Okay, so we list the property. Now the first question, okay, I've got a showing request. How much notice do I need to give my tenant? Well, the answer is very simply, you have to give 24-hour written notice to the tenant unless they've actually agreed to accept electronic notice. You have to serve documents at the property, and the showing has to be between 8 a.m. and 8 p.m. If you don't give the 24-hour prescribed notice and you try to enforce that walkthrough, you could actually end up, impeding with the tenant's rights to reasonable use and enjoyment of the property, which could put you as a landlord in default of the lease. So that's the first thing. Now, a lot of people confuse this because agents will call me and say, Ricky, well, the tenant's given me notice now that they're leaving. In that situation, it's no longer 24-hour written notice. It's reasonable notice, and the showing has to be between 8 and 8. So 8 and 8 is the key period. Now, we book the appointment, the buyer walks through, and the buyer says, this is great, but the existing tenant, their lease is way too low. It's $1,000, market rent is $2,000, and if I buy this property, I'm going to evict the tenant. Well, guess what? There's no such notice. If you are an investor and not an end user, you cannot give notice to the existing tenant to vacate the property so you can simply rent it out to somebody after the closing. This is illegal, and the penalties are very substantial. It's $25,000 if you're an individual, up to $100,000 if you're a corporation. Now, let's go to the next step. Let's assume that the buyer is an end user. If the buyer is an end user, you have to be so careful because they have to occupy the property for at least 12 months after vacant possession is provided. Now, the standard documents that we use when we're brokering these transactions as realtors, we use the OREA documents. So the OREA documents by default say that vacant possession is going to be provided. So if you're representing the seller as a realtor, if you're a seller using these forms, you have to appreciate that by default that such vacant possession is going to be provided. And so you need to tailor your contract specifically to suggest that you will file the requisite paperwork. The paperwork in this situation would be an N12. As soon as the property is sold firm, you have to make sure your closing is at least 75 to 90 days out. And the way the notice is served is it's served at the end of the month. So, for example, we're in December now. If I sell the property December 10th, my notice won't actually give effect until January. So January, February, which means my earliest closing would be March 1st, assuming it's a weekday. So it gets very specific in a situation like that. Once the notice is served, a lot of clients will say, should we now initiate the next process? Well, the next process is then to serve the L2, which gets you your date in court. And when I talk to clients, I always say it's a good insurance policy. Your contract, like we've discussed in many of the other shows previously, is like the sun. Everything else revolves around it. And so your contract has to be drafted to the effect that if the buyer does not obtain vacant possession because the tenant doesn't move out, the buyer needs to assume the tenant so that the seller is not in found in breach of contract. You've got to be so careful with these provisions.
Wow. So even if you serve notice, Ricky, suppose I sell a property on December 15th and they want to close March 1st. Yeah. So what you're saying is the tenant does not have to leave because you can't pretty much evict them until 75 to 90 days after you've given them notice, which would be effective January 1st.
That's right. And so when you look at the N12, it actually says on the face of the document that it's a legal notice that could lead to an eviction. It's not an actual court order. Mm-hmm. So what happens is after the N12, the landlord can immediately serve the L2, pay the prescribed fee, and get a date in court. Once they're in front of the tribunal, the member then looks at the case and looks at the merits of the purchaser. The purchaser should probably be there or have some sort of a certified affidavit ensuring that, they've got on the record evidence that they intend to move on. Because if a tribunal member doesn't buy the story that the buyer's going to move in, they could refuse to order the eviction. And if you don't have an eviction order, you can call the police, you can do whatever you want. Nobody will be able to remove that tenant from the property. The only party that can remove the tenant from the property is a sheriff or a bailiff, and they would only be enforcing an eviction order that the board would issue. So if you don't have the good graces of the board in that form, your tenant's not going anywhere. And if your deal's not structured carefully, you as the seller are in a lot of trouble.
Now, Ricky, what if the landlord wants to change the game plan a little bit, wants to evict a tenant, try to get another tenant in for more rent? How does that scenario work?
This is illegal. So, obviously, if the parties come to terms, if they settle these things out, it's usually cheaper to buy out a tenant and throw a little bit of money around to resolve the disputes, if any. But going back to the fact of the case that you're proposing here, there's actually no legal grounds for you to evict an existing tenant so that you can simply rent it out for more after the fact. It's very, very, very specific. And in fact, if it turns out that your notices are fake or if there's an issue, these things can come back and really affect you in the future. We actually had a situation where there was a case where the tenants had agreed to rent increases which were illegal. They were not the prescribed amounts. And after the closing, the new landlord took occupancy and assumed the tenant. And then the tenants hired a paralegal who then advised, hey, these rent increases, the paralegal advised that the rent increases were illegal, and they were actually able to repeal some of the rent increases that were not lawfully increased.
Ricky, what if a tenant refuses lease? So their lease is over January 30th. You've given them the notice. The place closes in March. We agree to have them stay until March, until the new buyers take over. However, March comes around, they refuse to leave. What happens?
And that's why you have to make sure you file the L2 simultaneously. As soon as the N12 is served, the next day you file the L2. You have that piece of paper in your hand. and it's a small fee for what I call an insurance policy. If they don't leave, then the buyer and seller can agree to an extension. Make sure your contracts are worded so you have the wiggle room for something like this. Now you call the sheriff and bailiff, you change the locks with a locksmith, you enforce the order, and the tenant's removed, and the transaction will subsequently close.
Wow, you're a wealth of knowledge on this. Now, if our listeners want to get a hold of you, Ricky, to discuss this in further detail, what's the best way to reach you?
Anytime. I'm at 416-731-8478. Again, 416-731-8478.
I'm sure you're going to get a lot of calls after this show. Thank you very much.
Anytime, guys. We'll see you again next time.
Take care. Asif, please remind our listeners how to connect with you directly.
They can reach me at 416-985-KON. That's 416-985-5426.
And that's our show for this week. If you missed any part of On the Market, go to our website, 1059theregion.com. I'm Tina Cortez. Thanks for listening.
Need to connect with Asif Khan from RE/MAX Prime Properties? Call him, 416-985-KON. That's 416-985-5426. Or email asif@thehomeshop.ca. CA.